Very good afternoon, everyone. Thanks for joining us for the January 2022 monthly Labourlaw updates. There are not many amendments for this month, just that in the Bihar, they have brought in the professional tax to take it more in an electronic form. So the registration, as well as even if your establishment is to cancel the registration, everything happens electronically. And similarly, all records pertaining to professional tax, you update electronically. So they brought in some amendment to their rules to that effect. Apart from it, there's no major significant change in the law in this month. The Haryana government, as you know, there's already been, we have been pointing out about the local candidate regulations that are there. So in that, they have brought in some quarterly reports to be given and the registers to be maintained with an identification number for each employer. So that is also, that's a change that the Haryana government has brought into the rules. The payment of Labour Welfare Fund has been enhanced. I mean, the time frame has been given up to 31st January in Karnataka. In ESI Corporation, there is a scheme called ABVYKAB, by which they provide up to 90 days of full wages in the event of somebody being retrenched or being jobless. An employee during his lifetime, once he can avail this, and that they have now said that to avail it, you should be worked at least 12 months prior to the unemployment. He should have worked and should have contributed for 78 days. Then the employee would be entitled to claim 90 days wages to sustain his family when he finds another employment. The petrol pumps in Tamil Nadu were not required to register under the Factories Act. Apparently, the government said that's not required because of Legal Metrology Act 2009. Though they are in two different verticals, for some reason the government had said that. Now the government has come out with a clarification saying, even in fact, petrol pumps and LPG dispensing pumps will come within the ambit of the Tamil Nadu factories rules. An amendment came to the Tamil Nadu government, to the Tamil Nadu Labour Welfare Fund Act. Questions were being raised as to whether that amendment has taken effect, on what basis the fund should be paid. But the government has issued a clarity that the existing old rates on that date sufficient if it is paid. So the new Amendment Act has not taken charge. So the quiz question for this month is the definition of employee and the code on wages. Who is not included under it? Is it an unskilled worker, a clerical worker, apprentice, or supervisor? Who stands excluded from this definition is the quiz question. When we go on to see changes that certain governments have been doing, we just got to see that the government of UK has published a consultation paper on flexible working arrangements. Even as on date, that system is available. So today, an employee, after he joins an employer and he serves for 26 weeks, he could make a request to the employer for flexible hours. This is all, even prior to COVID, they already had it. Now, the consultation paper says it doesn't need to wait for 26 weeks. Even from day one, the employee can make a request for flexible hours. And the flexible working, it could be like when he starts, when he ends, or work from home. These are all are already there. They're making it even more flexible. So should such amendments be brought in India as well to give flexibility to employees? And it's only a enabling power that's given. It is not that an employee can demand it as a matter of right. So something similar could be thought even in India. It's something for us to ponder. In this month, Knowledge Corner, we have tried to discuss about the Rights of Persons with Disabilities Act, in particular, obligations of a private employee. The Right of Persons with Disabilities Act 1995 was the first of the enactments. This enactment did not cover private institutions. It was only for the government institutions that were there. But in 2016, this act was amended with the new act coming in. The new act required it's applicable even to private employers. The term company has been brought in, and therefore there are certain obligations which are being cast under the private establishments also under this Disabilities Act of 2016. So when we look at it, what kind of obligations are there? You're required to frame an equal opportunity policy. In fact, a few months back, we had pointed out that in Tamil Nadu that they've come out with these where how to register it, and this policy has to be registered with whom. So you need to have a policy. You should ensure that your hiring policies and there is some kind of you try to ensure at least 5% of your employees are persons with disabilities, or that's again not a mandate, but 5% you should try to ensure is what they say. As I said, the policy should be there and it should be registered with the Chief Commissioner or the State Commissioner. How this could be achieved would be a challenge for private employers, but even in government, when they call for recruitment, let's assume 100 persons, they say 5% is kept for disabled persons, but under that quota. But if you look at it, many a times these quotas don't even get filled and these posts remain vacant. Being so, that will certainly be a challenge, but there is a provision under the Act. Therefore, we thought we should bring it to the notice of all our audiences for this. A few cases also we stumbled upon on this. One was where a person had he suffered from what is called as a writer's cramp. It's a locomotor disability. When he made his application itself, he made a request that he needs a scribe to write the exam. But UPSC said, no, we provide scribes only for blind candidates, cerebral palsy, and with certain locomotor disabilities where the impairment is more than 40%. The Supreme Court said that you can't take such a stand, and they provided for a scribe for this candidate. So how the courts have interpreted these acts, this act in particular, to enhance it. The next case law also is to that effect. This is where the government was paying to the disabled, for the blind, whose disabilities of blindness alone, they were being paid a transport allowance. Hearing impairment is also one such disability, and therefore people who the Deaf Employees Welfare Association filed, and they said, the Supreme Court said that disability is a common phenomenon. You can't discriminate among the disabled people, and therefore even those who are deaf would be entitled to this transportation allowance that the government was paying. One aspect which I missed out to point out is the term disability also includes acid attack persons. So even they have been brought within this 2016 amendment. So even they are covered. You would need to now check how far your establishment is covered under this act. Going on to our Know Your Codes segment, the occupational safety requires every employer in the event of closure of their factory or industrial establishment to intimate the same within 30 days. So there is a specific obligation for intimation on closure within 30 days. And under the Code on Wages, if any amount is due to an employee is entitled to and it is not paid, it's punishable up to a fine of rupees 50,000. So these two provisions is what we thought we'll point out this month. We have all been talking of all the laws that are there for the organized sector, but the next look of the government seems to be on even the unorganized sector. So the ministry has begun a process of collecting the data with regard to the unorganized sector across the country. And a few states have given the highest numbers of this registration still now. Private employment, the age of recruitment in the government has been increased in Meghalaya. Going to the case laws, this is one particular case law where pertaining to fixed term employees. people were being engaged on fixed term employment of 2 years, 24 months tenure, but that was being renewed year on year, and up to 8-9 years people at work, and they had been at the end of the fixed term contract, it was not renewed, and they were left without an employment. They have approached the Bombay High Court directly, and the Bombay High Court has kind of given a via media, because no doubt it's a private employer against whom a writ has been filed, and there are certain issues, but courts have come to the aid of that kind of fixed term employment. So in the new IR code, there is provision for fixed term employment. What would be the impact? What those FTEs mean, and could we just have them forever? Questions that are being raised. This decision that may come out finally could let us know as to what the courts think on these engagements of fixed term employment. This is again on a payment of Section 17B. As you know that when an employee gets an order of reinstatement and the employer decides to challenge the award, the employee would be entitled to Section 17B wages. There's all been a lot of judgments on whether the from when it has to be paid, and whether the minimum wages can be paid or the last drawn wages should be paid. In this judgment, the division bench of the Delhi High Court has held that the in favor of the workmen, and they have granted him 17B wages in this. On the complaints part, these are the various complaints. Professional tax remittance would be the complaints that will need to come in many states this month. The answer for our quiz question is that the term apprentice is not included in the code on wages. It's for obvious reasons. Apprentices are not employed, but they're just students or trainees. That's the reason why that's not been included. Thanks for joining us this month. We hope to see you again on 26 February 2022 at 4 p.m. Thank you.